Welcome to Amidaedutech. Like and subscribe our channel Amidaedutech. And Bilkis Bano case has become a national issue. On August 15th to 2022, 11 rape and murder convicts were released, and this became a national issue. Now let us look into the case from the civil exams perspective. The Sabarmati Express arrived at the Gujarat's Godhra station on February 27, 2002 morning. The 15 persons riding in the coach S6 of the train were burned to death in the fire that broke out in that coach. So there were about 10 children and 27 women among the victims. The 48 other passengers on the train sustained injuries. The Sabarmati Express had left Muzaffarpur for its destination of Ahmedabad. At least 2,000 Karasevaks who had travelled to Ayodhya at the invitation of this Vishwa Hindu Parishad had boarded the train in order to attend the Purnahuti Mahayagna. The Yagna was a part of the construction of the Ram Temple program. The incident triggered a massive riots in the state in which over 1,000 people were killed. The riots broke out on the evening of that day and continued for 2 to 3 months across the state. So now let us look into this Bilkis Bano. Bilkis Bano was 5 months pregnant at that time, abandoned her village of Randikpur along with her 3.5-year-old daughter and 15 other family members out of the fear for the outbreak of violence. So they sought safety in the Chaparwad neighborhood. On the other hand, on March 3rd, they came under the attack from a group of 20 to 30 persons carrying sickles, swords and sticks. The 11 accused men were one of the assailants, that is Bilkis, her mother, and 3 additional women were viciously attacked and raped. So 8 of the 11 Muslims from this Randikpur, 8 of the 17 Muslims from this Randikpur hamlet were discovered dead, while the 6 were still missing. The attack was only survived by Bilkis, a male and a 3-year-old. So according to the numerous reports, the Bilkis awoke 3 hours following the incident, and after obtaining clothing from an Adivasi lady, went to the Limkheda police station to file a case. Once in the Godhra rescue camp, the Bilkis was sent to a public hospital for a medical exam. The National Human Rights Commission and the Supreme Court both took up her case, and the latter subsequently requested that the CBI conduct a probe. So after the accused in the case were taken into custody in 2004, the trial began in Ahmedabad. But after the Bilkis expressed worries that the witnesses might suffer harm and the CBI's evidence would be tampered with, the Supreme Court decided to move the case to the Mumbai. So in accordance with the Indian Penal Code, the special CBI court sentenced these 11 defendants to life in jail on January 21, 2008 for rape and murder and unlawful assembly. So due to lack of evidence, the court cleared 7 further defendants. During the trial, one of the defendants also passed away. So according to the court, the Bilkis was sexually assaulted by accused, and her daughter Saleha was slain by one accused by smashing her to the ground. In May 2017, over 10 years after the gang rape case was filed, the Bombay High Court upheld the conviction and life sentences of 11 defendants. The Supreme Court also granted Bilkis a compensation in 2019 in the amount of Rs 50 lakhs, marking the first time it has happened in the case involving the riots of 2002. The Dadhan Chief Justice of India Ranjan Gogoi, together with Justices Deepak Gupta and Sanjeev Khanna, had penned the following statements for the Supreme Court. It is extremely evident that what should not have happened has happened, and the state has to make compensation. And then recently, why these prisoners were released? One of the defendants had filed to the Gujarat High Court for a reduction in the sentence under the section 432 and 433 of the Code of Criminal Procedure. The High Court rejected his appeal while stating that the Maharashtra and not the Gujarat was the proper authority to decide on his remission. The Maharashtra High Court actually sentenced them to jail. So he filed a plea in the Supreme Court pleading that he had been in jail for 15 years and 4 months without remission as of April 1, 2022. So in its order dated May 13, 2022, the top court stated that since the crime was committed in Gujarat, the state of Gujarat was the appropriate government to examine his application. The Supreme Court directed the Gujarat government to consider the application for premature release in terms of the policy dated July 9, 1992 and may decide within 2 months. The Gujarat government constituted a committee after the Supreme Court ordered it to investigate the possibility of his sentence being commuted. A committee was established a few months ago and decided unanimously to commute the sentences of all 7 defendants in the case. So they obtained orders for their release and after the state government approved the recommendation. On 15th August 2022, the 11 defendants in the Bilkis Bano case were released from Godhra sub-jail. The additional chief secretary for the Home and the Gujarat defended the charge, telling that the Supreme Court had asked the government to take into account the early release of these 11 convicts under the state's remission policy, which was in place at the time they were found guilty in the case by the trial court. So these 11 people were found guilty in 2008 in Mumbai by a special court. The Gujarat was operating under a remission policy of 1992 at the time of this conviction, that is 2008. The 1992 policy is not very clear who can receive remission, who cannot receive remission is not clear under that policy. The Gujarat changed and updated its prisoners remission policy in 2014. So according to this new policy, this 2014 policy, there are a specific standards about what kind of offenders can and cannot receive relief in that policy. So we all know that the governor or the president may give a pardon or lessen the sentences of the court even if a minimum is set, which distinguishes the authority of the pardons under the Article 73 and 161 of the Constitution from judicial powers. So according to the Articles 161, the governor of a state has the authority to mitigate, suspend or revoke the sentence of any individual guilty of breaking any law pertaining to an issue within the scope of the state's executive authority. So according to the section 432, the power to suspend or remit sentences, that is when any person has been sentenced to punishment for an offence, the appropriate government may at any time without conditions or upon any conditions which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. But according to the section 433, the power to commute the sentences, that is the appropriate government may, without the consent of the person sentenced, commute this. So but according to the section 433A, it restricts on the powers of the remission or commutation in certain cases like this one. The convicts should serve a minimum 14 years of substantive imprisonment. Now let us look into the various cases related to this remission. The highest court bench held by Justice D.Y. Chandrachud stated that the state cannot use its remission powers arbitrarily as recently as April 2022. In state of Haryana versus Mohinder Singh, the court emphasized that the remission should be granted in informed, fair and reasonable manner. The Supreme Court ruled that in a Rajan versus Home Secretary Department of Tamil Nadu, that the granting an early release is not a question of privilege but rather a power given to the competent government together with a duty. The remission shall not undercut the essence of the offence committed, the court said. In Lakshman Naskar versus Union of India, the court had outlined 5 considerations that the state should make when deciding on a remission. They are whether the crime is an isolated act of criminal behavior that has no impact on the society, whether there is a chance that the offense will be repeated in that future, whether the convicted person no longer has the ability to commit crimes, whether there is any justification for keeping the convicted person in prison, and the socio-economic circumstances of the convicted person's family. The apex court stated in Union of India versus Sriharan that the presiding judge's opinion would provide information on the factors such as the type of the crime that was committed, the defendant's criminal history, their backgrounds, and other pertinent factors, allowing the government to make the right decisions regarding whether or not the sentence should be commuted. So after all, it is the duty of the states to prevent unfortunate situations and to prevent crime, as the Supreme Court noted in Nandini Sundar versus Chhattisgarh. The court took into account the targeted violence and commissions of the offences affecting the human body and against the private and public property by mobs under the garb of the self-assumed and self-appointed protectors of law in its 2018 decision and the Tahsin Poonawalla case, which dealt with mob violence and lynching. So it was observed by the court in this case that the horrendous acts of mobocracy should not become the new normal. The state was cautioned by the Supreme Court not to turn a deaf ear to the mourning rumblings of its people. So considering that the offences were committed against Ms. Bilkis in the context of violence that had an impact on the entire state, the concerns expressed by her family after the convict's release, as well as the reportedly warm welcome given to the 11 men when they were let out of jail, make this Lakshman Naskar ruling pertinent in this case. Now let us look into let us wait and see how this Supreme Court might take what kind of stance on this. Thank you.